Hello and welcome. I am Arizona Lawyer Julie LaBenz, and in this video, I am going to give you step-by-step instructions about how a family court trial unfolds. So with these instructions, you're going to be able to not only, number one, prepare for your trial, but know what to expect when you walk into the courtroom. So many self-represented litigants have no idea how a trial works, and that really puts them at a disadvantage. Because if you don't understand the flow of the trial, number one, you can't properly prepare. And number two, it just adds to your anxiety. It adds to you being surprised the day of your trial. And it prohibits you from really taking advantage of how this procedure can help you win your case. So as I'm going through this explanation, if I talk about something that you don't understand, throw a question in the comments so I can record a video later that will address your question. And it'll also help me see where you guys are at as far as understanding how the family court trial process works. Now, good news, I am in Arizona. However, the court trial procedure is generally the same across the United States. So this procedure that I'm going to tell you about is going to apply no matter which state you're in. Now, here in Arizona, there are some changes to the rules that have been implemented to seek to streamline cases when self-represented parties are involved. And I'll talk to you about some of those changes as I get into the presentation. Okay, so number one, once you've gotten notice of your case being set for a trial, and keep in mind, not every single hearing is a trial. There's status conferences, there's mediations, there's judicial settlement conferences. So a lot of self-represented parties think that any hearing that's set is automatically a trial, but that's not the case. Instead, a trial is going to be set, for example, in relation to a motion for temporary orders or a final trial to resolve all issues in the case. So pay close attention to the court order that is setting the hearing that's next in your case and read that carefully and really make sure you determine what type of hearing your case is set for. And if it's set for what's called an evidentiary hearing or a trial, that's where you're going to present evidence. Now, when you get that order setting the hearing, you want to mark that date on your calendar and you want to make sure you're clear if it's in person or if it's virtual. And, if it's in person, make sure you know exactly where the courthouse and your particular courtroom are. If it's virtual, make sure you've got the link to appear virtually and that you, have the infrastructure with the technology in order to appear remotely. Now, in addition to putting the date on your calendar, you're also going to want to make sure that you've disclosed any evidence that you want to use at the hearing. Disclosure is only shared between the parties and it's not filed with the court. But if you don't disclose, for example, a witness you intend to call to the stand to testify or a particular document you want to use in it as an exhibit at the trial, then the other side can object, objection not disclosed, and you won't get to present that witness or that evidence. And you want to disclose sooner rather than later. Ideally, you have all of your disclosure provided to the opposing side at least 30 days before your hearing date. If you're closer than 30 days to your hearing date, then I encourage you to get your disclosure out as soon as possible. And your disclosure is going to be a list of your witnesses, their contact information, a brief summary of what they're going to testify about, and then a list of the documents you want to use as exhibits, along with copies of those documents. And that can be electronic copies or hard copies. And again, that's not filed with the court. It just goes to your opposing party or their attorney if they're represented. Now, you'll want to mark on your calendar the deadline to submit your exhibits to the court. and you'll want to make sure that you submit them in the format that the court requires. So does your court require you to submit hard copies of your exhibits and, go and file them with the court? Or does the court require you to electronically upload your exhibits into the court's evidence portal? You'll want to figure that out and figure out the exact steps to take and how to do it. You don't want to leave that to the last day when your evidence is due, because that not only just causes more stress for you, but could cause you to miss the deadline if you're not able to figure things out the day it's due. So you'll want to have your exhibits very well organized. They need to be numbered. They need to, be together. Ideally, you've highlighted the parts of particular exhibits that are important. So, there's a lot of detail that goes into exhibit organization, but the main point here is you want to comply with the exhibit submission deadline. Now, prior to your trial, you're going to want to create what's called a trial outline. And in your trial outline, this is where you write a script of everything that you're going to say when it's your turn to talk. And I'm going to next go into when it'll be your turn to talk. But that's going to be your questions for the opposing party and their witnesses, as well as what you're going to say when it's your time to testify, and then any questions for any witnesses that you intend to present. Okay, so you've disclosed your witnesses and exhibits to the other side. You've submitted your evidence in accordance to the court's rules and on or before the exhibit deadline. And then you've drafted your trial outline script. Now, let's go through what that script looks like so I can help you with how to draft that. And this is where I'm going to talk about how a trial unfolds. Now, one thing to take into consideration is whether you're the petitioner or the respondent. Whichever one you are doesn't give either side any particular advantage, but it does determine who goes first in presenting their evidence. And in every trial, be it an evidentiary hearing or a trial, the procedure is the same, and the petitioner presents their case first. So if you're the petitioner, that means that you're going to be going first. And that means that you want to be prepared with whoever your first witness is going to be. And you need to decide, are you going to be your first witness? Do you have any other witnesses? Are you going to present them before you or after you? Now, you don't have to have other witnesses. And I'll do a separate video about how to determine when you should utilize other witnesses. But for now, let's just use a hypothetical example where the only witnesses are you and your opposing party. Now, you're going to enter the courtroom and the court's going to call your case, and the judge is going to address any preliminary matters and then ask you if you want to do an opening statement. You don't have to do an opening statement. You could say that you waive it, but if you're going to do an opening statement, it should be very brief. This is not your closing argument. This is not your entire case. This is just you giving a brief summary, again, brief, about what your trial presentation is going to be about. So for example, good morning, Your Honor. Today I intend to present one witness, which will be myself, and I will present evidence regarding the issues of parenting time and child support. Thank you very much. Like that simple, okay? But again, an opening statement is not required, and you can just say, Judge, I waive opening statement if you don't want to give a brief summary of what you're going to say. Either way is fine. Now, after both sides have given their opening statements or waived them, then it's time for the petitioner to call their first witness to the stand, which in our example will be the petitioner taking the stand. Now, if you're the petitioner, then you are going to get sworn in, you swear to tell the truth, and you're going to take the witness stand. Now, the first thing you want to do is you're going to want to adjust the microphone that is at the witness stand to make sure that it's at a comfortable place for you to speak into it and be clearly heard on the record. Now, at this point, if you don't have a lawyer, you are going to just get to talk. And when you talk, I encourage this to be a scripted presentation because you can, if you don't have a lawyer, you can take notes up with you to the witness stand when you testify. And those notes ideally will be bullet points with what you're going to talk about. Now, you want to go into your testimony with the mindset that you're talking to somebody who knows nothing about you and your case. And that somebody is the judge. Now, of course, the judge will have read your file, the judge will know something about your case, but the judge has thousands of cases, hundreds, thousands, it depends on your judge. But the bottom line is the judge has a lot of cases. So you want to make this simple and easy for the judge to understand and ideally rule in your favor. That means that you have this mindset that you're talking to somebody that you've never met before. And what that means is you're using enough explanation when you talk so that the listener can follow what you're saying. In other words, don't use nicknames. Give the appropriate backstory. If you do use a nickname, explain who you're referring to. You know, give sufficient information so that the listener, the judge, can follow exactly what you're talking about. And one helpful way to present your evidence is to go in chronological order. Okay. Now, when you're presenting your evidence, you're going to want to know what are you trying to prove? You don't just want to get up there and talk. And really, the judge is not your therapist. So you do not want to go up there and air all of your grievances. Instead, you want to be really clear about what are you trying to prove and what is your requested outcome. So if your trial, for example, is about parenting time, you definitely want to talk about what is the best outcome for your children and why. And you want to be specific. What is the exact parenting plan? In other words, the exact parenting schedule that you're asking the court to order, and why is that schedule best for your children? In that scenario, ideally, one of your exhibits is your proposed parenting schedule so that you have something that the judge can take and look at after your trial and know this is exactly what the petitioner is requesting for parenting time. Now, when you talk about why it's best for your children, you'll want to determine if your state has a statute in the family law code about the best interests of the child standards. In Arizona, we do. It's under ARS 25-403, and it's a series of, I believe, 11 different factors. Now, not every factor is going to apply in every case, but if you're in Arizona and you're presenting your parenting time request, you're going to want to talk about each of those parenting time factors in 25-403 that applies in your case and present evidence about them. Because in Arizona, the judge is required to base their decision on those best interests of the child factors. So find out what those are in your state, and this gives you a guide for what to talk about while you're testifying. You want to talk about those best interest standards. Now, there has been a recent rule change in Arizona where the judge, if you're representing yourself, the judge can ask you questions. So if you're in that situation where the judge is going to be asking you questions, listen to each question, answer it, but still be prepared to present your evidence. Okay? Still be prepared to present your exhibits. Still be prepared to make the points that you want to make, either in response to the judge's questions or by letting the judge know that you have additional evidence that you want to present outside of the judge's questions. Now, in our hypothetical, the two issues in the trial were parenting time and child support. So after you've presented your parenting time case, then you transition to your child support evidence. And a great way to do that is a technique that is called signposting, which means you just make a quick statement about what is the next evidence you're going to present. So you'd finish up your parenting time evidence and you'd say, okay, now, judge, I'm going to talk about child support. And ideally, one of your exhibits that you're going to present to the court is your child support worksheet or your child support calculation. And you'll want to go through each factor in your worksheet or your calculation and explain where your numbers came from and why your numbers are correct and what the ultimate outcome is that you're asking the court to order in regards to child support. Now, once you've finished up your testimony, the next step is the opposing party or their lawyer is going to get to ask you questions on cross-examination. On cross-examination, you want to make sure that you're consistent with what you just testified about on direct. And you want to make sure you're really listening to the question and that you're answering the question that is asked. It is entirely possible that you are thinking about the last question and miss the current question that's being asked. It's entirely possible that if there's an attorney on the other side, they ask a question that you don't understand because they use a legal term, or maybe they ask two questions in one. The bottom line is to slow things down and ask for clarification. Ask for the attorney to repeat the question if you didn't hear it. Ask the attorney to rephrase it if they use language that you're not clear on. You will not look stupid. The important part is to make sure you understand the question that you are answering. Now, once the opposing side is done with cross-examination, then it is your opportunity to testify one more time on what's called redirect. And the purpose of redirect is to testify further about anything that came up on cross-examination that you want to give a bigger explanation about. So if there, for example, were questions on cross-examination that were posed to you about a particular incident that occurred with your children, and you were limited to just short yes or no answers, but there's a lot more to the story that you want the judge to know, that's your opportunity on redirect, is to tell the judge that additional information about something that came up on cross-examination that you believe is relevant and that you want the court to know about. Now, it is possible that nothing comes up on cross-examination that you need to provide more testimony about. So what I'm getting at is don't feel like you have to testify more on redirect. You'll only testify more on redirect if something came up on cross-examination that you want to clarify and provide, backstory on. All right, once you're done with direct examination, cross-examination, and redirect, then you are done as a witness and you leave the stand. From there, your case ends, and now the respondent, it's their time to present their case. So then the respondent would take the stand, they'd get sworn in, they'd take the stand, and then if they have a lawyer, their lawyer would ask them questions. If they don't have a lawyer, then they get to testify. Once they're done with their direct examination, then it's your turn to ask the respondent questions on cross. Now, on cross-examination, you are allowed to ask leading questions. And a leading question is basically a statement, comma, correct. So, for example, a leading question would be, your name is Julie LaBenz, right? Yes, it is. No, it isn't. It's a statement, comma, correct, statement, comma, right, statement, comma, isn't that true? And I encourage you to definitely script out your cross-examination questions because you're going to be under a lot of stress in the courtroom during the trial. And cross-examination questions are definitely, are challenging to just create on the spot. So this is something that's very good for scripting. And keep in mind that cross-examination doesn't need to be long to be effective. You could ask 3 to 5 questions that are very powerful and have a really strong cross-examination. So don't feel like you have to go on and on and on cross-examination. Instead, you want to have a strategy What exactly are you wanting the other side to say yes or no about? And that's what you want to draft your questions around. Okay. So let's, in our example trial, child support was one of the issues. And let's say you're wanting the other side to agree that they earn $25 an hour. You could ask a question. Isn't it true that you currently earn $25 per hour? Or you earn $25 per hour, right? So you get the point. You want to be very clear. What are the things that are critical for you to prove to get the outcome you want? Those are the things that you can focus your cross-examination questions on. Now, once you're done asking questions on cross, the other side will get to testify on redirect, and then their testimony is done. Now, as the petitioner, you have the opportunity, if you want, to take the stand one more time on what is called rebuttal. The purpose of rebuttal is to present any evidence in regards to the respondent's case that you didn't already present evidence on when you presented your case in chief. Now, there may not be anything for you to follow up on, or there may be. Now, if, for example, you presented your parenting time and child support case, and then the respondent takes the stand, and while they're testifying, they get into this whole alleged story that you engaged in child abuse, and you dispute this, and you asked questions on cross to seek to raise doubt about the story, but you want to tell your side of the story. That would be a great use of rebuttal testimony, is to retake the stand and testify about what really happened regarding these alleged child abuse accusations. Keep in mind, if you take the stand during rebuttal, which is optional, it's going to be that same flow of direct examination where you testify. You would again be subject to cross-examination, and then you'd have the opportunity for redirect. Okay, so if you presented rebuttal testimony or not, at that point, the presentation of evidence is complete. And then you move into closing arguments. And in your closing argument, this is where you want to tell the judge what you're asking for, how you're asking the judge to rule, and how the evidence that was presented at the trial supports your requested outcome. So, judge, this is just an example of what could be part of a closing argument. Judge, I presented Exhibit 3, which is my proposed parenting plan, and the evidence presented today showed that this parenting plan is in the best interest of my child, and this is why. You heard testimony from me that da-da-da-da. You heard testimony from the other side about da-da-da-da. Clearly, my proposed parenting plan is best for our minor child. Something to that effect. Once you're finished with closing arguments, then the evidence is submitted to the judge for the judge to make a decision. The judge can either rule right there on the spot, or, at least in Arizona, the judge has up to 60 days to enter a ruling. If your hearing has been a temporary orders hearing, it's very common for the judge to rule on the spot. And the other thing to keep in mind is that temporary orders hearings are 30 minutes usually, so you've got to be really prepared to present a quick and comprehensive trial in about 15 minutes, doing everything that we just talked about. All right. If you have questions about this information, put your questions down in the comments. Also, if you're wondering about the steps of how to get any of your exhibits actually admitted into evidence during your testimony, watch my last video about a common mistake with evidence, because in that video, I walk through exactly how to get an exhibit admitted into evidence at trial. And just as a quick wrap up, I'm just going to give you the trial procedure just really quickly as a short overview. There's opening statements, then it's the petitioner's turn to present their case. The petitioner presents their witnesses, and for each witness, It's direct examination, cross-examination, redirect. Once the petitioner is done presenting their case, then it's the respondent's turn to present their case. They call their witnesses to the stand. It's the same procedure: direct examination, cross-examination, redirect. Once they're finished with their witnesses, the petitioner has the chance to present any rebuttal witnesses if they have any. Any rebuttal witnesses follow the same procedure: direct examination, cross-examination, redirect. At that point, it's the close of the presentation of evidence. Both sides will present closing arguments, and then the judge can make the decision right there at the conclusion of the trial, or the judge, at least in Arizona, has up to 60 days to enter a written ruling. Okay, I hope you found this presentation helpful, and I wish you success with your case. Please like this video, please subscribe, and please comment below. Let me know what questions you have, and let me know what you thought about this video. All right, thank you.